and Property Management Companies, Mr. Jim Fitzpatrick.
Mr Turner, it's a pleasure to see you presiding over this debate this afternoon, sir. I'm very pleased to see the Minister, the Honourable Member for Grantham and Stamford in his place, and also to see the Honourable Member for Worthing West, who has led on this issue in this House for a number of years now, and I know he wants to make a contribution to the debate before the Minister responds, so I'm very happy to see that he's here. Mr Turner, this is a growing issue. I have had a number of cases in my constituency in Poplar and Limehouse over the past 16 years from people in very expensive property, professional, qualified individuals, residents who'd paid large sums of money for the homes that they inhabit, and they're being ripped off by unscrupulous property management companies and individuals who have spawned these management companies who've been exploiting these individuals. However, that's only my own local perspective. This is a national issue. There are something like 5 million people, as I understand it, in leasehold tenure in the United Kingdom, one of only 2 countries which has this degree of tenure. And the statutory instrument which we debated last week in committee said that 40% of all new properties are of leasehold tenure. Now, in East London, where we have massive regeneration and lots of new properties and lots of conversions, I think we get one of the biggest areas in the country for leasehold tenure. And this is not a situation which is going to go away. This has been growing for years and will continue to grow. I know that when we were in government, we tried to address it to a certain extent, and we had a number of stabs at it, but sadly we haven't covered it, and I'm very hopeful that the Minister will be able to say that the Coalition are still very interested in this subject and want to move it on. And it's not just leasehold tenure. I have to declare I live on an estate which was previously managed by Peveril, which was previously owned by the Tenguis brothers, which is quite notorious. I know there's an OFT report out this Friday, and I'll mention that later on. But I'm a freeholder. But because I'm on an estate which is run by a property management company, I've got a covenant, therefore I'm included and therefore have a role to play. So I want to get that on record so that I'm not accused of any conflict of interest here. And as I say, Mr Turner, despite the reforms, there are still problems. Some of the specifics in terms of the problems: unfair charges for repairs, for insurance and for electricity supply, complex procedures for residents to seek redress because they are supposed to be informal. When residents get to land valuation tribunals, which I know is being reformed in itself as a structure, property management companies turn up with heavyweight legal teams, with barristers, and put people under massive pressure. And one of the difficulties is that even where the residents win their legal cases, the legal costs, which were supposed to be capped at £5,000 but aren't, the legal costs incurred by the property management companies, which lose the case, suddenly find themselves as being on the bills of the residents the following year as part of the service charges, which is grossly unfair and adds insult to injury. Of course, I give way to my honourable friend.
I congratulate him on raising this very important issue. Would you agree that these problems are a particular nightmare for elderly residents who simply can't cope with the pressure they're put under and the extent of the cost rises?
My honourable friend anticipates a point that I will make later on, which is that these problems are not restricted by class or by age or by geography. They relate to pensioner and retirement flats of value of only £50,000, right the way through to £1 million properties in my part of East London. And in that instance, when we're talking about pensioners in their retirement homes, then the trauma and the stress is even greater on those individuals and communities. And although there are some restrictions in the legislation about the level of fees and about the ability for local authorities to prosecute these property management companies when they see there's a transgression, local authorities appear to be unwilling or unable to respond legally. I've got a number of cases which I will just mention very briefly, Mr Turner. At my own constituency, I have two high-profile cases running at the moment on Canary Riverside and on West India Quay, both companies owned by the Yanis Group, operated by Opticon Assets, in major disputes with residents, and have real problems in getting those situations resolved. The right to manage estate ballots procedure is very complex, especially where there are absentee owners who are subletting, and it's a very expensive procedure. In the Kingsmore estate in Brighton, it cost residents £30,000 and they failed to be able to secure the right to manage their own estate. An individual, Mr Dennis Jackson in Battersea, over a £7,000 dispute with his property management company, incurred £76,000 legal costs and nearly lost his £800,000 flat, which he now has to sell to pay for his legal fees, which is a level of the professional individuals we're talking about, having to relocate to be able to deal with the problems they've had to face. We've had predators like the Tenguis brothers in Peveril, the largest property management company in England, with many complaints of onerous, unnecessary maintenance work and exacting fees, as my honourable friend says, from pensioners and others. And there is no requirement in these companies to demonstrate value for money or to ensure quality of service. I'd be grateful if the Minister in his response could bring us up to speed with the OFT investigation into Peveril and the leasehold inquiry, which I believe has been announced. And I know that he won't be able to say too much without compromising embargoes, etc. But I know that there have been announcements, and it would be good to be able to hear for the record exactly what's happening. I want to congratulate the Leasehold Knowledge Partnership, both in terms of the full OFT investigation into residential leasehold and also the securing of the OFT report into Peveril Cirrus's price-fixing racket involving ward and call and electronic door systems and retirement leases, back to the point from my honourable friend, which I understand is due out this Friday, and the Minister can confirm that. And I also want to say thank you to the LKP and Carlex for the briefing and the information, particularly the fact that they were able to tell me about the successful repayments of £1 million to residents at St George's Wharf, £500,000 to residents in Charter Quay, £400,000 to residents at Chelsea Bridge. These are huge sums, Mr Turner, and demonstrate that something has gone badly wrong in this sector. So my final points, Mr Turner, we had the SI and we had the redress system, and I did ask the Minister's colleague, the Minister who was presiding over the SI, about the redress scheme, and he was able to say that the redress scheme, which has now been extended, means that if you're not in the redress scheme, then you will not be able to operate. Perhaps he could say a little bit more about how the redress scheme will make it simpler for residents and tenants to be able to get fairness in the system. I wonder if the Minister can give any information about the OFT inquiry, about its duration, how long it may take, and the liaison between his department and colleagues in BIS about it. And principally, the fundamental question about whether or not the government does accept that this is an issue, and it has to be addressed, and there has to be solutions in due course. The concluding
Sorry,
point.
We must divide. We're going.
Right. Okay. Sorry, Mr. Turner. I didn't realise. I didn't pick that up on my hearing aids.
We'll be back at 16:53.
Mr Turner, thank you very much. I was just concluding my remarks, and my final question, just to recap on where I was to ask the Minister whether or not the government accept that this is a growing issue, it's not going to go away, and it does need action. And certainly the OFT announcement seems to suggest that certainly the authorities recognise it, and it may be because the government have told them. I'm not entirely sure. It'd be good to hear his view on that. And my last point, to go back to the question and the intervention from my honourable friend from Oxford, is that leasehold crosses class and age boundaries. everything from expensive lofts and expensive apartments through to retirement bungalows and flats. It is not geographically limited either, so this is an issue which affects the whole country. In the statutory instrument, his ministerial colleague said that he would be prepared and happy to meet with myself, the Honourable Member from Worthing West, and other colleagues who have an interest in this issue. I'd be grateful if he could confirm that. Obviously, the OFT inquiry means that things will be happening in tandem, but it would be good to put this directly to the Minister and the Department at some time in the future. I'd be grateful if he could respond to that. Thank you, Mr Turner.
Mr. Chairman, can I thank the honourable gentleman for Poplar and Limehouse for taking the opportunity of the Statutory Instrument Committee discussion to organise for the government to pay attention, and congratulate him on having this debate here today. I welcome the Minister, and I hope that he'll pass on to his colleagues in his department and to ministers in the Department for Justice that things need to happen to be fair, to give people freedom, and to avoid what I've called criminal behaviour in leasehold deals, in price-fixing cartels, in the cheating of freeholders, in excessive exit fees and fiddles, opportunist lawyers playing the system, and of a number of times when, in my view, the Property Chamber or the Leasehold Valuation Tribunal has not been led with the kind of determination which has got justice for people sorting out ordinary disputes between a leaseholder, a managing agent, or a freeholder. I would like, for example, to invite the barrister Justin Bates to say out loud what are the ways in which opportunist managing agents and freeholders can frustrate an application to go to the Leasehold Valuation Tribunal, or the first stage of the Property Chamber, where, as the honourable gentleman said, the fee is fixed at £500. But if a lawyer explains to the respondent, the managing agent or the freeholder, you can make applications to delay the hearing, you can apply to go to the county court, you can bounce back between the two. And by the way, if you take advice of some lawyers, if you have an application for a right to manage, it can take up to 18 months for the courts to dispose of the fact you do not have to have the letters RTM in the proposed management company which will replace the managing agents appointed by the freeholder. As my honourable friend the Minister will know, the freeholder appoints the managing agent. The freeholder gives instructions to the managing agent. The freeholder has every interest in the managing agent doing what the freeholder wants and not what is right by law, and not what was necessarily in the interests of the leaseholders. I first got involved in this indirectly when my Worthing home, which is leasehold, the other 5 owners and I took up an offer from the freeholder to buy the freehold. It took us, I think, about 2 exchanges of letters to agree a price. We had a managing agent who had been appointed by the freeholder who was very good, and we continue using that managing agent now. That's an example of how the system is supposed to work. And if we'd had a dispute over price, we could have gone to the Leasehold Valuation Tribunal and solved it. We didn't need to. Also in my constituency was a block of flats where a number of people found themselves poor, old, some of them dying, applying to get back money that's wrongly been taken from them, and it took well over a year to get the case into the Leasehold Valuation Tribunal. Partly because of my intervention, the freeholder recognised what they'd done was wrong. They offered £70,000 to the leaseholders. That was accepted. It was less than they would have got in court, but at least it solved the problem. And if you take the work of Martin Boyd and Sebastian O'Kelly, who've been rightly mentioned by the honourable member for Poplar and Limehouse, their work with Carlex and LKP have saved hundreds of people millions of pounds. The government have an advisory service called LEASE, the Leasehold Advisory Service, which does its best, but it doesn't have enough money, it doesn't have the resources, and sadly it has to take advertisements from people who shouldn't be advertising at all, let alone in a government advisory service. And I name Mr. Benjamin Meyer, who, when shown a report by the Judicial Conduct Investigation Office, resigned his position. If he hadn't, the report would have been made public. Because he resigned, having read it, we don't know what's in it. Actually, we do know what's in it, but we haven't got it formally, because we know the things he's been doing. You only have to read the comments of the chairman of the Leasehold Valuation Tribunal to know. So I would say to the Minister, besides answering the debate today, which I'm grateful, can you please make sure that the whole of government come together, follow the OFT investigation into what's going wrong in commercial terms, look at what the Serious Fraud Office had and the OFT have on Peveril, who've been named. And I'd also like them to look at Mr. Israel Moskovich, who again has played the system to avoid his leaseholders in Plymouth getting into a dispute resolution, the Leasehold Valuation Tribunal, or the right to manage or the right to purchase. I think that the ARMAQ, the Association of Residential Managing Agents, with our former colleague Keith Hill as their arbitrator, have got some of the right ways forward. But it ought to be illegal for any managing agent or freeholder to take a commission from an insurance company without having open books and without showing that what they're doing is in the best interests of the leaseholders. I'm very pleased that the Right Honourable Member for Kingston and Surbiton, who's also the Secretary of State for Energy, and I had meetings with the OFT, and that's led to the decision they've made this week to have the investigation. There's more to come. Bluntly, it is wrong that were I a convicted fraudster who came out of jail yesterday, I could set up as a managing agent today, and I wouldn't have to meet standards which are necessary and obvious. Not just for those who are in big flats on the Thames, expensive ones with lawyers, but the small people who can't get anything other than a leasehold property of their own as a place to live and hopefully to live without undue cost. We must make the system so that the managing agent has a duty to the leaseholders who do the paying to get the best possible service at the right price, and they don't have to pay for things which aren't needed. The OFT will come out over the door call systems where hundreds and hundreds of blocks of flats, probably about 6 in my constituency, I know some in the Chancellor of the Exchequers, some in the Prime Minister's, probably most members have got them, where they were forced to have renewals that weren't necessary at prices fixed in a cartel, and it wasn't actually a cartel because the two other so-called bidders weren't doing the work. If I were 99% of the market, I don't think I should get relief from the OFT rules by confessing my sins after the Serious Fraud Office have passed a case to the Office of Fair Trading. I won't go on, but there will be other opportunities when this House can consider these matters. What I would say is the Honourable Member for Poplar and Limehouse has rightly spoken for millions of people, and it's time that we in Parliament and in the judiciary took the action which will stop this level of scandal, of cost, of frustration and of worry for ordinary individuals just trying to live quietly at home.
Thank you, Mr. Chairman. It's a pleasure to serve under your chairmanship. I feel much safer with you watching us over us. And I'd like to congratulate the Honourable Member for Poplar and Limehouse on securing this debate and for speaking with both passion and persistence on an issue that I know is of great importance to his constituents, and also to thank my honourable friend for Worthing West for his contribution and again his persistence in pursuing this, some might view as arcane, but in lots of people's lives a very, very real source of worry and distress. I'm taking this debate today, Mr. Turney, in place of my honourable friend, the Housing Minister, as he is required to respond to an Opposition Day debate on business rates. I may not be able to cover all of the issues, and if I try, I may not cover them as intelligently as he would have done, but I know that he will be happy to write to honourable members to follow up on the issues, and also, of course, to hold the meeting that the honourable member mentioned, and to which I know he has already committed. Residential leasehold is indeed an important and growing housing sector. Many leaseholders, like my honourable friend, are of course happy with their home in the sector, but some, we recognise, are not. And the Housing Minister's postbag makes that very clear to him. The Honourable Member for Poplar and Limehouse has raised a wide range of issues, and I will attempt to address as many as I can in the time available. I'm glad to have been asked how the redress schemes will assist leaseholders and others. Since 2010, the government has become increasingly aware of the issues in the residential leasehold sector, particularly over the quality of service. The new Enterprise and Regulatory Reform Act of 2013 gives the Secretary of State the power to require all residential letting and property management agents in England to be members of a government-approved redress scheme. We are making good progress implementing these powers, and we expect to start improving such schemes early in the new year. I'm happy to give way.
There's just a very brief technical point, which I don't expect you to answer today, but can you make sure, in leasehold, in law, a leaseholder is a tenant, but not all tenants are regarded as including leaseholders. So could he try to check, and perhaps his honourable friend could come back to us and say whether that will cover leaseholders as well as what people normally refer to as tenants?
Thank you, Mr. Chairman. My understanding is that it does, but we will certainly write to him just to reassure that. But certainly there's a sentence which I skipped over, which nevertheless seems to imply that is the case. But we will confirm that to all of the honourable members here today. I wanted to talk address briefly the issue of the right to manage legislation. And I have to admit that this is the first time I've ever heard about it, and I may not make as much sense as the honourable members deserve. The leasehold right to manage legislation is designed to be available to as many private sector leaseholders living in blocks of flats as possible. The right was designed for use on a block-by-block basis. Applying this legislation to estates is complex and might result in the right becoming less rather than more accessible. The point was made that the right to manage ballots can be complex and potentially expensive. The legislation sets out in detail the procedures to be followed, and these must obviously be complied with by all involved. These provisions aim to protect the interests of all the parties involved, including those of the leaseholders. But I'm sure that my honourable friend, the Housing Minister, will be happy to discuss that further if there are further developments that seem appropriate. The honourable member talked about high charges to leaseholders for repairs, insurance and utilities. The law provides leaseholders with a range of important rights where service charges are concerned. These include the right to be consulted, the ability to challenge the reasonableness of charges at independent tribunal, and the right to obtain information. And one of the honourable members did mention the particular circumstances of older and sometimes vulnerable leaseholders who find it onerous or stressful to go to a tribunal or to exercise their rights. I'm sure that all honourable members are aware that free initial legal advice is available from the Leasehold Advisory Service, known as Lease, which is funded by my department. Happy to give way.
And I'd like to add a tribute to Anthony Essian, who leads Lease as Chief Executive. But I think he would agree, and I'm sure that if the Master of the Rolls as Head of the Civil Courts of Appeal would agree, that there needs to be a trawl through judgments by the Leasehold Valuation Tribunal and on appeal, and gather up the times when these poor, ordinary people have been frustrated at great cost and worry, and, as the Honourable Gentleman said, have the costs pile up, which then come back to them as service charges. So I think that more work is needed, please.
I hope, Mr. Chairman, that I will be able to address, at least in part, that particular question. The question of the ability of property management companies to recover their legal costs from leaseholders by adding them on as service charges for the following year, even in the cases where the leaseholder was the successful party. It will depend on the terms of the individual lease whether the landlord can recover his legal costs, and if so, how and in what way. And even where a lease does allow recovery of legal costs as a service charge, the courts and tribunals still have the power to prevent this from happening by issuing what is known as a Section 20C order if they judge that it is appropriate to do so. Obviously, that does require you to go through the tribunal or the court to get the Section 20C order. Each case will be determined on its merits and independent legal advice should be obtained, but where leaseholders believe they have grounds to do so, they should consider applying to the court or tribunal for such an order. I wanted to also just briefly address the questions about the OFT. And of course, there have been a number of different reviews, and I want to make sure that I get the information about the different reviews right. So I'm advised that the OFT is carrying out an investigation into property management groups which use associated companies to supply security systems and other services. And I believe that the OFT expect to report on this very shortly. The OFT is also undertaking a separate market study of property management, and that is only at its initial stages, and I'm not able to say exactly how long that will last or when it will report. I do know that the OFT are seeking views on the scope of this study, and that should be provided by January. I'm absolutely certain that my colleague, the Housing Minister, will be able to provide more detail of that when he meets with honourable members. The honourable member who secured this debate asked at the end, in a sense perhaps the most important question, which is, does the government believe nothing to see here, move along? Or do we believe that this is an area where there are problems, there are abuses, And while some steps have been taken, indeed, including the steps taken through the recent Act, that nevertheless there may be other subjects that need to be looked at. And I can reassure him and other colleagues that this is an area where we do understand that there is abuse, that there are unfortunate people and some people in vulnerable circumstances who are not best placed to defend themselves, and we're very open to conversations about ways to improve matters without obviously massively overcomplicating systems or adding hugely to the burden either on the taxpayer or on leaseholders themselves. But we are very much open to those conversations.
Just add as my...
I hadn't finished. I've got another sentence, Mr. Chairman.
Would he agree with me that as well as that, each of the professional standards bodies for surveyors and for bankers and others, including the barristers, should review whether the actions of some of their members should have a review as to whether they're meeting professional standards? Because it seems to me that sometimes people do things illegal, that's clearly wrong. Sometimes do things against the public interest, and that should not happen in a profession.
Well, it's certainly the case, Mr. Turner, is it not, that in other professions you can be struck off a profession even if you have not been found guilty of a criminal offence for breaking the codes of that profession. And I'm sure that every profession will want the public to have full confidence in their professional standards and that they maintain them and that they enforce them.
The question is that the sitting be now adjourned. Order, order.